Hello and welcome to our first ever Leverets podcast. I'm Owen. Today I'm joined by Daniel, who's a barrister at Hare Court, who is part of our team in the case we're going to be discussing today, which is the Republic of Mozambique's Tuna Bonds case, insofar as it related to England and Wales. Judgment has very recently come out, which is why we're talking about it. Happily for our clients, this judgment doesn't affect them because they secured settlements on the eve of the 3-month trial and then a few weeks into trial, meaning that they were out of it completely. I wondered if perhaps you could explain a bit of the factual background to the matter.
Sure. So it's a case that involves 3 very large loans to Mozambican companies that were involved in. One of them was involved with protecting Mozambique's coastline using rapid response units. The other was involved with exploiting Mozambique's tuna industry and was essentially providing fishing vessels. And the third was a shipyard to service the vessels for both of those projects. And it involved just over $2 billion worth of loans to these companies that were backed by sovereign guarantees. And the claims were essentially that these projects and these loans and the guarantees were all affected by wide-scale corruption in Mozambique and bribery of Mozambican officials. And this is just the English commercial courts dealing with one part of what's become a very large scandal, as you said, known as the Tuna Bonds Scandal.
After that tuna fishing fleet, and then also known as in Mozambique the hidden debt crisis.
Yes,
because those guarantees were allegedly hidden from the public
and the IMF.
And the IMF. So I suppose to explain the end of those projects eventually failed, and around 2016 the banks called on those debts, which then became more widely known to the public and to the IMF, leading to a crisis in Mozambique, an economic crisis. And then eventually that's led to the claim here, but via quite a circuitous route, which has involved, criminal proceedings in New York, including against our clients who have pleaded guilty to criminal charges and await sentencing. We currently, as we speak, have the trial of the former Minister of Finance of Mozambique in New York. There's also in South Africa.
Yes, there were related proceedings in South Africa to do with extradition that went all the way to the Constitutional Court. In this country, there were questions over the arbitration agreements involved that went all the way to the Supreme Court here, and there were big questions involving sovereign immunity of the President of Mozambique. And it's a case that has had subsidiary pieces of litigation going on all over the world, and this is just the latest chapter.
Exactly. And in Mozambique, there was their trial of the century, where they had about 20 defendants in a specially built courtroom inside a prison in Maputo, whereas headline news every day, practically, in the Portuguese newspapers, which we had to keep an eye on during the case. And there are criminal investigations into our clients in Mozambique, which meant we had to have quite a sort of overarching view of everything that was going on. The English litigation wasn't in a vacuum. We had to be aware of all these different elements, what's happening in Mozambique, what's happening in the US.
So I was part of the counsel team involved with preparing and representing our clients in the hearings in England and Wales. Could you tell me a bit more about the background to how we got to those hearings and preparing for them from the side of Leverets?
Absolutely. So we started off representing the 3 members of the Credit Suisse deal team, who are these former bankers who had been involved in the transactions, in the financing for the transactions. Eventually, due to carefully managing conflicts, we went forward to trial with 2 of those clients. In terms of the scale of the task, there was a vast amount of disclosure to do, looking at our own clients' disclosure.
I mean, can you give us an idea of how much disclosure was involved in the case?
So overall, disclosed documents, there are about 400,000 documents. Behind that, there are millions of documents that had to be sifted through, collected, reviewed, often involving foreign languages, which meant that for us as a team, while we had our core Leverets team, we took on 23 specialist document review lawyers who were able to go through those documents, deploy their language skills, because a lot of them were foreign qualified lawyers, and ensure that we had the relevant documents from our clients' collections, because there's quite a stringent duty to provide relevant documents in English proceedings.
And as I recall, there were 12 parties to the proceedings and 10 sets of legal teams. And with our document review team, I recall us being probably the most dynamic in terms of being able to do not only quick disclosure, but probably the most effective disclosure, where we were able to pick up on the most relevant documents. And we, compared to other parties, face very few issues and challenges to our disclosure.
Yeah, we certainly faced a lot of scrutiny. We had to explain at every step what we were doing with our collections, how we were searching those documents. But we answered those questions, and we took that forward and gave the disclosure we needed to. In terms of the practicalities, because of the 3 clients and the risk of conflicts arising, we had to have 3 completely siloed teams with confidentiality walls between them.
And disclosure played an important role in the proceedings overall, in particular the Republic of Mozambique's ability or inability to disclose relevant documents.
Yeah, absolutely. So the case really, the matter in Mozambique itself kind of inveigled its way throughout the Mozambican government. Mm-hmm. And that involved the Mozambican Secret Service. It involved the office of the current president, mm-hmm. who was the defense minister at the time of the transactions. It involved other organs of government like the Council of State. And the Republic was having difficulties with giving its lawyers access to those documents to be able to review them for relevance. There were various stages of the parties scrutinising what the Republic was doing. There was a declaration that the Republic could assign its lawyers as having need-to-know status under Mozambican law to review those documents at source. And eventually it got to the stage where the parties applied for a strikeout of the Republic's case. This was something that we, as a firm, had raised, I think, quite early on in the proceedings, that there was a risk that because of the disclosure process and the reasons why the Republic might not disclose certain documents, this risked whether there could be a fair trial.
This became known to the parties as the Battle Royale, and it continued to be an issue up until and during trial, as to whether trial could be affected by the lack of disclosure by the lead claimant.
Absolutely.
By the claimant in these proceedings.
Yeah, absolutely. So trial was due for October to December last year. In June, we were arguing about whether the case could go ahead at all. The judge decided that it could go ahead, but there would be inferences drawn against the Republic due to its disclosure difficulties.
Just before trial started, virtually on the eve of trial, our clients settled their claims the claims that had been made against them by the Republic of Mozambique. Yeah,
so that led to a kind of timeout in proceedings, a couple of days for the parties to take stock and work out what shape the trial was going to take for the next 3 months.
Because we weren't out completely.
Yeah, we still had the contribution claims from the shipbuilder Priminvest against us, saying that if they were liable to the Republic, then we should make a contribution. to what they owed the Republic. That meant that we had a couple of weeks where we were still in the trial. The witness evidence changed. Our clients decided not to give evidence given the new shape of the trial. And it also led to an application by our clients and Credit Suisse to say that Privinvest could no longer bring its case. Because their case relied on findings that the Republic, factual findings that our clients were involved in the fraud, but the Republic had taken those factual claims out of its statements of case. So there's this argument that we made that we were no longer involved in the claim. We weren't part of that underlying factual claim, so we couldn't be part of the contribution. Privinvest argued that we were, and that the Republic's case was unclear. We argued that, well, in the alternative, if the Republic's case is unclear, then it's not fair for our clients to face this 3-month trial without knowing what they're what they're accused of.
Yeah, I think for me that was quite an interesting part of the trial, was other parties also being in similar positions against Privinvest, for example, Credit Suisse, and each party being able to use different arguments against these contribution claims and effectively cornering Privinvest from different angles, leading to the eventual settlement of the Privinvest claims against our clients.
Yeah, so then once the Privinvest claim was settled, that meant we were out of the proceedings completely, and it just leaves the Republic's claim against Privinvest. And
what I've taken away from these proceedings is how important it's been to have a large team who are able to communicate effectively with each other and use the resources that are available as best as they can. I think we were very lucky in having using software that was efficient and worked with relativity, and being able to have a counsel team that had different areas of expertise. We had Peter Knox-Casey, who led the counsel team, and we had Charlotte Pope-Williams, who has a lot of experience in finance and banking. And there was a particular utility in having people such as yourself, who comes from a Magic Circle background, where you have a lot of experience with dealing with large cases such as this, and how to manage both clients but also other parties, and dealing with the enormous amounts of correspondence that you had.
Yeah, and I think it's an absolute proof of concept that Leverets can handle these large cases. It was really one of the biggest cases last year in the commercial court. And the judge kept on referring to how complex and high value the case was. And we were able to really keep an even footing with the other parties. We had a core team, we had our Leverets core team, and then we had, as I said, those document reviewers we brought on. At the start of the case, it was largely Rupert, our head of practice, doing the advocacy. As it just sort of ballooned, he took on more of a case management role, and the advocacy was done more directly by Peter Knox, with a sort of, at one point there was another separate application, a discrete application, where we involved Paul Bowen, KC. We also had Natasha Jackson, and we also, due to having eventually the 2 different clients, we brought on Christopher Convey to advise and represent specifically Serjan Singh, which also worked very well. Which is another point, it really gave us a good education in managing a group of clients. So our clients aren't actually able to speak to each other due to the terms of their US cooperation. And it meant that we had to stay above them, kind of keep marshalling information and getting a consensus without them being able to talk to each other, which is probably quite a unique situation where you have clients with a shared interests that aren't able to communicate with each other.
Yes, and I'm sure not only keeping them apart, but also being able to effectively ensure that they are able to participate in the proceedings effectively. For example, ensuring that their disclosure meets what's required, and also ensure that the witness statements they produce adhere to the very new practice directions that are required in the commercial court. And that in itself, just those two aspects of the case were a large project in themselves, never mind actually
absolutely
taking everything to trial.
Yeah, and in terms of, sort of personal development for me, it provided my first opportunity to interviewing document review lawyers for us to take on, which was an interesting experience to be on the other side of the table. As a firm, we really enjoyed having our group of 23 document review lawyers, and we're looking at ways we can deploy that knowledge and those relationships we've built up to assist in document review processes. So watch this space on that point there.
What sort of things are the firm doing post such an enormous trial? It must have been an adrenaline come down for the whole firm. So,
we had a well-deserved break, I suppose. But yeah, we're working on new cases. We've recently been involved in one involving Africa, which has hit the headlines, involving Zambia. Mm-hmm. So sticking with Southern Africa. We've got a good diet of various bits of High Court litigation going on, and we're open to new things and I hope to get involved.
I hope not all the litigation involves 600 pieces of correspondence a week.
No, hopefully not. Yeah, we got up to about 20 letters a day, I think, on the case. How about for yourself? What are your takeaways from the case?
Like I said, working with a large effective team I found extremely rewarding, and being able to bounce off ideas of people with different experiences I thought was invaluable. And being able to have the experience of seeing how different teams work, because we were able to see not only different advocacy styles from the different counsel involved in the litigation. Like I said, there were 10 different legal teams involved, each with large counsel teams, but also seeing how effective different tactics were. It was an enormously valuable learning experience.
Yeah, and we have a good sort of precedent bank.
Yes.
There were so many applications throughout the proceedings. There were so many CMCs. We've got lots of skeleton arguments and lots of applications we can look back on for all sorts of different issues. Yeah, so it's a useful knowledge base to have that. And I suppose personally, it's been quite formative in my career. I was working on it very solidly from when I joined Leverets 2.5 years ago up until it finished. It probably compares to my experience in my previous firm of Thomas Cook, which went into liquidation 3 weeks into my time as a qualified solicitor and dominated the rest of my time there. This case has had the same sort of effect here and has been an important case for me to be involved in.